I'm going to call this meeting to order. This is the Standing Committee on Justice and Human Rights. It's meeting number 38, and as per orders of the day, we are televised and pursuant to the order of reference of Monday, June 16th, 2014. We are dealing with Bill C-36, an act to amend the Criminal Code in response to the Supreme Court of Canada decision in Attorney General of Canada versus Bedford, and to make consequential amendments to other acts. We have a number of witnesses, again, joining this panel with us this morning, and from the Adult Entertainment Association of Canada, we have Tim Lambernos. I'm not sure if I'm saying that right, and Rudy Zicala. Close enough. Anyways, Mothers Against Trafficking of Humans is Ms. Grant. From the Sex Professionals of Canada, Amy Lebovich and Valerie Scott are here. And from the York Regional Police, we have the Chief of Police, Chief Joffe. Joliffe. And from Denmark, we have, all the way on video conference, Professor Ekberg, who's with the University of Glasgow School of Law for this first panel. So what we will do is we will go through the witness list as presented. You each have 10 minutes from each organization to present to the committee, and then we will do our rounds of questions. So first, from the Adult Entertainment Association of Canada, the floor is yours.
Thank you, Mr. Chairman. Il faut que je parle en anglais seulement.
I will have to speak in English only because this is a very complex issue, so my apologies for that.
We've submitted into the clerk today. By way of disc, I'm going to have to submit an actual hard copy to Monsieur Pazet afterwards, too. Our Adult Entertainment Association is a stakeholder organization designed to serve the needs of the exotic dance industry, which is the exotic dance entertainers, the strip clubs. It is based in Ontario. It is a self-regulatory model. We have some of the owners that are here from Ottawa today. And it's a way in which our organization has been put together to help self-regulate. There's a 1-800 number put in place for entertainers to call should they have issues that they can report confidentially. We work together with municipalities to create various amount of educational materials, etc. The Bedford decision does not apply to the clubs. This is not an area where we wanted to go. This is not a venue where we want to do something. Our proposal that we're submitting into the committee today is a reaction to the Supreme Court decision, 9-0. And I heard the Minister of Justice the other day, Mr. Chair, with all due respect, state that he felt that the Justice Department felt that this bill would stand up to a legal test. My question to the members of the committee is, are these the same individuals that said the last one would stand up to a legal test? They should be fired. In any other business, they would be. It's uncalled for. This particular study that we're submitting in is an opportunity for the courts to look at a model that would work. It involves health. It involves safety. It involves a number of things. The 5 main reasons that this study was done independently by Mr. Chiscala points out that this is a ready-made answer. The adult entertainment clubs could take on this aspect as an enhanced licensed area under the same umbrella of an adult entertainment club. And there's 5 major reasons that the study points out, a 5-month study. Number 1 is the zoning. There would be no need for a red light district. There would be no need for official plan changes, no need for zoning change. The licensed adult entertainment clubs, by definition, are services designed to appeal to erotic or sexual appetites or inclinations. Have the word sexual in it, has the word services. That wouldn't change. They are known entities. They have a good track record at protecting women. They already work together with police. And we have a very valid association who work together with governments, which is going to take some time. It's the reality of things. This is not an issue that a few lawyers can deal with. It's going to take a lot of input from a lot of people, and it's going to be part of my recommendation. So the legal test, it is a slippery slope that we go on, and it is uncalled for any minister to take on the fact that if you are going to be deliberate and know that there's going to be a court challenge, that's almost malicious intent in reality. And you should be held liable, either through a civil suit or even criminal charges, should there be ramifications afterwards. That's the reality of things. So the Charter itself, and I hold it up as a prop, this is the Canadian Charter of Rights and Freedoms. Section 7 of the Charter guarantees the protection and safety of all persons in Canada. All persons, not 31,000 select persons that decide to write online. All persons in Canada are guaranteed that right under the Charter. Mr. Triscala is going to talk about the study itself, about how it talks about implementing, taking on enhanced services. I just want to have 3 recommendations. And the first is that there needs to be an outside legal review of this. Morris Manning is an excellent choice. Teresa Simone, another person. He has a great reputation. Number 2 is there is no way. There has to be enhanced dialogue. There has to be a working group put together, and an extension has to be asked for past the December 13th. And when that's done, our request is that our study be sent into the court as a model to say, is this what you had in mind? Is this what we're talking about? Because in reality, it was at 9-0. Now, on my last point, I have 2 last points before I turn it over to Mr. Triscala. Am I okay with time? Okay. Okay. I wanted to invite all members of the committee, including Mr. Chair. Mr. Deckard has already said he cannot attend, but I think it's important for members of the committee to understand what the adult entertainment industry is. There's different atmospheres. The 2 clubs tonight, 8 p.m. For a site facility tour. There's no media permitted. It's strictly work. And invite all members of the committee. 8 p.m. for a site facility tour at the Fairfax, 27 York Street, and 9 p.m. at the new 1560 Triol Street. The last thing I wanted to point out, which we talked about earlier, Mr. Chairman, is the flaw in advertising. And this is a section of a publicly issued magazine that talks about what's flawed in the legal definition of preventing sexual services. None of these places advertise for sex. The definition of sex is not defined in the legislation. Teresa Simone created one, but they talk about oral massage. They talk about full service. They talk about Greek, as I pointed out. These are all codes. We all know what. Do you know, Mr. Chair, what full service means, for example? No, it means. I'll enlighten everybody. It means intercourse. It means everything. So all these codes also mean things too. So I just wanted to turn the rest of the time over to Mr. Triscala.
Great. Good morning, and thank you for having me here today to speak to you on Bill C-36. My name is Rudy Chicala Martinez, and I am the Principal of Municipal Policy Consultants in Toronto, Ontario. I have been involved in the development of public policy in the area of adult entertainment, both as a regulator and a private consultant for almost 15 years. I'm also the author of the Enhanced Adult Services Study that Mr. Lambrinos referred to. From my experience, I can tell you that although the federal government lays out the regulatory framework for prostitution in this country, it is actually the municipalities that have the greatest impact on how prostitution is managed. This is the case because irrespective of what the federal government does, prostitution finds a way to continue to exist. It may transform its modus operandi to accommodate legislation, but it never goes away. Municipalities understand this very well, and they have responded in a number of ways. In Vancouver, Calgary, and Edmonton, municipal authorities have been licensing escort services for more than a decade. Not unlike the businesses themselves, which carefully set up their operations to make sure that they don't technically run afoul of the law, these municipalities have carefully worded their own bylaws to ensure that they do not directly contradict the criminal laws, but which at the same time indirectly regulate the business of prostitution. So you see, we have a situation in which the different levels of government are not working together effectively to come up with a realistic, practical, balanced, and of course, constitutionally valid solution. The model proposed in Bill C-36 does nothing to alleviate this matter. Aside from not responding to the issues raised by the Supreme Court, it also does nothing to help the provinces and ultimately municipal governments to deal with the real issues: the safety of the women involved in prostitution, their social marginalization, and their economic disenfranchisement, all things created by current as well as the proposed legislation. The study I conducted includes 103 key findings and 9 major recommendations with 37 actionable items. In the short time I have before you, I would like to provide you with a synopsis of the study's recommendations and approach to their implementation. First and foremost, an effective model needs to have outcome-based objectives against which the effectiveness of the approach is measured. Of course, this means having valid and reliable metrics, which in turn means that there has to be relevant, consistent, and timely data available. In Sweden, the government set as one of its objectives to reduce the violence against prostitutes. As several independent studies have pointed out, the government then went on to claim that it was achieving its goal because there were fewer prostitutes working on the streets, which was then interpreted to mean that there was less prostitution overall and therefore less violence as well. The government in Sweden never had valid and reliable metrics. It simply made very fallible assumptions. In fact, what has happened in Sweden is that the legislation there has simply driven prostitution deeper underground, not reducing levels in any significant way. And by doing so, it has also made it more dangerous, as sex worker focus groups have revealed. And here at home, police services, from the RCMP all the way to the local police forces, don't keep the kind of data that is needed to ensure that we are measuring what needs to be measured. So, the centralization of data collection by law enforcement authorities is one of the central recommendations of the study. Another set key of recommendations from the study focuses on the need to employ a harm reduction approach. We know that criminalization, whether explicit, as in the United States, or implicit, as has been the case in Canada and would continue to be so under the proposed legislation, simply doesn't work. We therefore need to focus on reducing individual, group, and social harm. This can only be done by redressing the laws and institutionalized norms that systematically victimize sex workers. Human trafficking, sexual exploitation, physical and psychological violence, social marginalization, and economic disenfranchisement are all issues that have to be addressed through a balanced combination of regulation and supports. An excise tax on services would go a long way to pay for such programs. Finally, the study makes a case for having all levels of government explicitly working together to come up with a strategy that does what I have just described. For each issue and sub-issue, there will almost always be a level of government that will be the lead and have the other orders of government play supporting roles. Without an explicit implementation plan driven by specific outcomes and validated by specific measures, any attempt at addressing prostitution risks becoming just another ambiguously unsuccessful attempt in a long line of similar attempts at dealing with this issue. I echo the sentiment said by Mr. Lambrinos that this committee should consider recommending to Parliament that further work be undertaken and that an extension for such work be sought from the Supreme Court. Thank you.
Association. Our next speaker is from the Mothers Against Trafficking of Humans. The floor is yours, Ms. Grant.
Thank you. Thank you for having me here today. It's an honor to be present. My name is Glendine Grant. I'm a wife, a mother, a grandmother, and the founder of MATH, Mothers Against Trafficking Humans. I'm not here today with any studies or data. I have a real story. I started MATH on April 18, 2010 as part of my way to raise awareness to human trafficking and educate anyone I can about the crime of human trafficking after my daughter Jessie Foster went missing. She was quickly known to be a victim of the crime. She's an international endangered missing woman and pretty much the most well-known human trafficking victim in Canada. Some of us even refer to her as the poster child for the crime. So my reason for being here is personal. I want to tell you a little bit about what happened to Jessie. When she was 17, she met a man in Calgary who became her friend. They stayed friends even after she graduated high school, got a job in her own apartment. And to me, this person was grooming her. That's my opinion. He is a recruiter and a pimp. His brother is a known pimp. We didn't know that right away, but when we found out, it fell into place. She was taken on 2 trips, which I always do trips because they weren't what you would want to go on. They took her to Florida, they took her to Manhattan and Atlantic City, and instead of bringing her home on the second trip, they took her to Las Vegas. And this happened after it was suggested to her that she prostitute herself the night before they were to leave because their funds had run out. And he didn't have any money for expenses to get them home. So she rushed downstairs and called me and was a little bit upset at the time, but said he's just being a jerk. I'm going back up to my room. So the next morning, she called and said, they're going to Las Vegas. She said nothing about what had happened the night before. She acted like it didn't happen. And I was scared. I didn't know what was going on. I just knew that it wasn't a normal situation. So when she got to Las Vegas, she called and said that she's going to stay there till her 21st birthday, which was 2 weeks away. 21 is the legal age in Las Vegas, so it also fell into place once she went missing. It didn't take her long to change her story. After the birthday story, there was an accident, then she had to stay for insurance, and then after that, she met a fellow. After that, she fell in love, moved in, and got engaged. This all happened very quickly. She was actually living with this fellow by June. She only got there in May. After she went missing, we hired a private investigator. She'd have been beaten, hospitalized with a broken jaw, forced to work at an escort agency and arrested for solicitation. And when I talk about Jessie, I talk about my honor roll student. She was into sports, music, dance, tons of friends since kindergarten, and never been in trouble ever in her life, not with school, friends, parents, anything. The first time she was arrested was in June. She'd only been taken there in May. She was arrested again in September. She went missing in March. It was 10 months after she was taken down there. And when we hired a private investigator, everything came out immediately. Her pimp had, or I should say her fiancé, had a bail bonds company he worked with all the time. This bail bonds company bailed Jessie out twice, plus all of his other girls who worked for him. And I know this because I actually talked to the bounty hunter that worked for him. This guy called me up, wanted to find Jessie. She was due for court and had a bail, and I told him, well, you find her because she's missing, and I'd be glad for her to go to jail. I don't care what. He was very touched by her story, and once that case ended and he had no contract, he came on pro bono to help us look for Jessie. He couldn't find her either. Now with Jessie, she's my second oldest of 4 daughters, and she's got a stepdad, my husband Jim, and I. We've been together almost 30 years, but yesterday was our first wedding anniversary. We just got married. I felt horrible doing it without Jessie, but we've done a lot of things without Jessie in the last 8 years. 2 of her sisters have become moms, and life has gone on as best as we can. We've coped with it. 2 of her sisters were still teenagers when she went missing. Her older sister was 23. So they were just entering their adulthood. So the problem with all that is they've had to do all this with a missing sister. And to do all that, you have to really learn to cope. They kind of took their key from me. I said, whatever we're going to do for Jessie, and we're going to do it with Jessie in our hearts. So some of us have coped, some of us haven't. Her father has not. He has... He is no longer working. His health has deteriorated. He's greatly overweight, and it's sad to say because he's a wonderful man, but this has destroyed him from the inside out. It's his daughter, and he can't cope with it. I'm very grateful that I have a supportive husband. He has a very supportive wife, too, but sometimes that's not enough. Jim's there with me all the way. Now, this is why I believe in Bill C-36. The biggest reason is because we can't have the alternative. We can't have prostitution and everything else connected to it, a legal occupation in Canada. We need to keep laws in place to stop it, and there's no safe ways for there to be legal brothels and streetwalkers with bodyguards, or pimps, as I call them. We know they're pimps, so we need to let them know this is not going to be tolerated in Canada again. We can't risk more and more people being forced into the sex trade if this was to be a legal job, as there would never be enough people to fill the potential job openings. And we truly cannot have any more victims like Jessie, any more family like ours. I mean, living this nightmare for 8 years, I mean, even 8 days or 8 hours is a really hard time. When Jessie first went missing, we all thought it was going to be over the next day, at the end of the week. First year comes along, it's just ongoing. Some people that are advocates, we can't live without them. But thank goodness they can take a day off or go on a holiday and get a little reprieve from this. I can't. I wake up every day, goes to Jessie, goes to what probably happened to her, and then it goes to my fight to stop this from happening. Another important fact, in my opinion, is that we need to stop this demand, because that's the only thing that's keeping it going. If we don't hold the pimps and the Johns accountable, it'll never happen. There are people who want to pay for sex, and there are people who are victimized into servicing them by some very cruel people. We need lots of funding for people to exit the sex trade. It's something that's needed, otherwise nothing else will work. There are many people who have told me that they are in the sex trade because they have no way out. They don't want to stay in it, but they can't afford to support their children and get some kind of an education. And none of them are receiving any counseling for the trauma that they've endured. And they've been told, literally, it's a catch-22. They want to leave. When they try, they fail, they end up back. And that, to me, is absolutely horrible. The men, women, and children need to get away back, to get their lives back. They need to learn how to live happy, healthy lives. And for them, with children, they need to do it for their kids, too. And it takes time and money. It's not easy. They want to live a life that they're proud of. I just spoke to a woman the other day. She messaged me on Facebook and asked me why I support this bill, and she does not, but she believes everyone has an opinion. We conversed for quite some time, And she told me, I will never tell my daughters what I do for a living. And to me, that just told me right there and then, that's not her choice of a job, of a career. If you want your children to make right choices in their life, they have to be told the truth. They have to know what's going on in their own lives and families. Otherwise, they're just falling. They need to know what their mother does for a living, and they need to be proud of everything. And as far as math is concerned, math has really helped me. I speak all over different types of events. Some I do just on my own with math. If it's in the Kamloops and District Crime Stoppers area, I go with Mark Price. He's the head of that organization there. And we just go to schools. We go to anything we can. We've been to a school in Boston Bar, BC, it's such a small place. Kindergarten through 12 is one school. But because of a missing young lady, she was missing for 2 weeks. And she came back, and everyone thought, thank goodness, she's back, she's fine. Then they started realizing she wasn't fine. So they brought us in to their school so we could explain to their students what's out there. I just, with me, it's become a personal crusade. It's my coping mechanism, and it's also my way to keep Jessie out there. I have no proof that Jessie's not alive or dead. So I go on the assumption that she is alive. And hopefully we'll find her one day. And when we do find her, she's going to see that there has been fights in her name, and change is brought about because I'm not just going to sit there. When Jessie went missing, there was a fine line between a missing person and a human trafficking victim, because everyone thought I was grasping at a straw. I needed an excuse, something to explain what happened to my daughter and where she went. And now we are 8.5 years later, and we have laws that are changing. Every day we're hearing about organizations being arrested and people being charged with this crime. When Jessie went missing, it wasn't even a known crime. People told me it doesn't happen in North America. It doesn't happen in Canada. And we now know it does. So we need to make a change. And I want to thank you for allowing me to speak on Jessie's behalf.
Okay. Thank you for that presentation.
Thank you.
Our next presenter is from the Sex Professionals of Canada, and the floor is yours. And I know Ms. Scott's having some difficulty with the lights, so.
I'm going to go first.
Okay. Thanks, Amy. The floor is yours.
Oh, I don't have to press the button? Yeah. Okay. I'm under no false pretense that many of you here will actually be invested in hearing me out. Really hear me. Sex workers are very well connected in our movement. We know what we need to keep ourselves safer and how to go about establishing more optimal working conditions. I've been involved with sex work community organizing for 11 years now, and in my 17 years of working as a sex worker, I have worked street-based for agencies and currently an independent worker. As a plaintiff in the recent Supreme Court case, which has become a broad discussion in the mainstream, the name Leibovich, my name, certainly has lost its anonymity. I don't want that loss of privacy and the stigma that I have faced to be done in vain. I don't want the rights of my colleagues, the rights that they have gained from this case, to be stripped away. Drawing on my own knowledge and expertise and that of the people who I have known and I have worked with over the years, I can tell you there is a clear disconnect between Bill C-36 and all of the evidence and education we have provided to the government about the policy perspective needed to move forward. Our priorities and concerns have been completely ignored. I'm not here today to tell you how to amend this bill. It's beyond salvaging. This is not a moral crusade to be won. It is a struggle to assert voices of dignity and human rights. We have consistently proposed an effective model which takes into account sex workers' realities and practical concerns. This is the New Zealand model of decriminalization. The rest of my time, in my mind, is best served by me explaining to you and imagining a point in time of my colleagues under the tyranny of Bill C-36. It's late, so stressed out. The cops keep harassing me, telling me to move. I gotta make more cash to get the things I need. Where are the others working tonight? Clients are so paranoid, not stopping for more than a quick minute before driving off. Freaks me out that these guys want me to get into their cars and we've only talked for 5 seconds. I heard some of the others were working out in Industrial Park. More clients are driving out around there. Does the bus go out that far? Could I even catch it at this time? Oh, look, there's D. He gives me the creeps, but I know he's good for it. I just checked into my motel and put my ad up on Backpage. Damn, that was expensive. Backpage prices have really gone up. They just shut down 2 other sites. I could advertise for free on one of them. I heard they're going to shut down Backpage too. How am I going to get clients then? Guys are not giving me their info for my screening. He called from a blocked number. I couldn't even check with the bad date list. The last guy that came over wouldn't even pay me at the beginning. He was so paranoid. I had to suck him off before he trusted I was not a cop. Then he tried to walk out without paying. One of my friends just got kicked out of the motel. Are the cops outside watching who's coming in and out? Clients are trying to haggle down my price. Maybe I should lower my rates. How am I going to pay my rent? As demonstrated by these very realistic examples, our lives as sex workers will be made much more precarious and anxiety-filled as a result of this bill, should it be implemented. We will continue to work, but under much more dangerous conditions. We will constantly be looking over our shoulder. We will still find ourselves under the specter of criminalization. We will lose our negotiating power for the rates we charge, for our safety, for the right to make demands about our comfort levels in providing certain services. We will still be unable to report abuse and harassment. We still won't have access to labor rights because under this bill, we are nothing but voiceless victims in need of rescue. We can do better than this for sex workers. As I have stated earlier, the government has the evidence and policy examples of a better way forward. I implore you to centralize the voices and concerns of my sex working colleagues. We cannot afford to wait another 6+ years for another Supreme Court challenge. Lives are at stake.
Pardon me, I'm very allergic to fluorescent lights and was told that the lighting in here would be halogen, which is not true. So, I will do my best here. With this bill, you are going to drive us so far underground and make us work under such difficult conditions, with many more people working within those difficult conditions, that violence is bound to escalate. There is no question. It is not theory. It is not hypotheses. We are going to start getting killed. There is no question about that. That was from Kathy, a witness at a parliamentary committee on Bill C-49, also known as the Communicating Law, on October 22, 1985. I was also one of the witnesses that day. We told you then what would happen, and you said, thank you very much, and went ahead and passed the bill. On December 20th, 2014, the Supreme Court of Canada struck down 1/3 of the Communicating Law and 1/10 of the Procuring Law and the Body House Law. It did so on the basis that the old laws compromised not only our health and safety, but were found on evidence to cause catastrophic harm. So why would this government not only reintroduce the old laws, but go even further and write new sections that will make our occupation even more dangerous than the old regime made it? Bill C-36 is not rationally connected to the Supreme Court's reasoning in Canada v. Bedford. The laws regulating the sex trade are important, not just in an obvious way for what they prohibit, but also for the conditions they create and their influence on how sex workers are perceived. When it is any other group other than sex workers, people intuitively understand that there is a direct connection between what the law says about a group of people and how individuals of that group are treated by others. When Russia passed laws to squelch the gay rights movement in June 2013, no one was surprised to hear of a rise in gay-bashing cases, or that those protesting the laws, not the bashers, were jailed. When Uganda passed a law that included life imprisonment for homosexual acts, and Nigeria banned same-sex unions and began arresting those suspected of being gay, we were not shocked to hear of beatings, torture, and murders. We know that criminalizing homosexuality leads to increased violence against homosexuals. It should be equally obvious that criminalizing sex work increases violence against sex workers. That is one of the reasons why decriminalization is so important to us. Laws don't just reflect society, they shape both attitudes and how activities are conducted. Social purity laws are particularly problematic. Think about the prohibition of alcohol in the U.S. in the 1920s. People didn't react by saying, "Oh, okay, I guess I'll never have another glass of wine." Instead, they found ways around the law. Prohibition enriched organized crime, kept the police busy, added risks that weren't there before, and criminalized the actions of a significant percentage of the population. The law shaped the way the activity was carried out. What it didn't do was achieve its stated aims. Of course, this will be the effect of Bill C-36. Our clients have been called horrible names lately. Perverts, pathetic, predators. But think who our clients really are. They are not the Robert Pictons or the Gary Ridgways of this world. They do not arrive on a shuttle from Mars at sundown. They are men who, for many different reasons, buy our services. And I must stress, our services. They do not buy us. Our clients are your fathers, your brothers, your uncles, and yes, your colleagues. The specter of parading them in front of the media and courts for the entertainment value of shame and humiliation is irresistible to those of the finger-pointing persuasion. But these are revenge laws, and revenge laws have no place in a just society. But when you tell society that we are criminals, that you want to legislate us out of existence, predators will take you up on the offer. We all know about the Robert Pictons and the Gary Ridgways of this world. Gary Ridgway, the Green River murderer, said, "I hate most prostitutes. I didn't want to pay them for sex. I also picked prostitutes as my victims because they were easy to pick up without being noticed. I knew they would not be reported missing right away and might never be reported missing." Ridgway was convicted of murdering 49 of my colleagues, but later confessed to murdering almost double that number. Bad laws serve us up on a silver platter to sexual predators. Most people, whether pro or con, aren't happy with Bill C-36. Spock's advice is to scrap the bill in its entirety. After all, as Justice Minister Peter MacKay said in a statement released on December 20th, 2013, a number of other criminal code provisions remain in place to protect those engaged in prostitution and other vulnerable persons and to address the negative effects prostitution has on communities. On that, and on that alone, we agree with Minister MacKay. There are a plethora of other criminal code provisions that specifically address extortion, coercion, procuring, assault, forcible confinement, human trafficking, and about 14 different laws protecting against the exploitation of minors. Spock's position
Scott,
is to let the
Scott,
laws that the
Miss
Supreme
Scott,
Court struck
could you
down.
get to a conclusion? You're way over time.
Okay. One sentence.
You can, yep.
Okay. Spock's position is to let the laws that the Supreme Court struck down expire, and that consensual adult sex work should be governed by employment and labor laws. Thank you.
Okay, thank you very much. Thank you for that presentation from the Sex Professionals of Canada. Our next is the York Regional Police, and the Chief is here with us. Chief, the floor is yours.
Thank you, and let me begin by thanking each of you, members of the Standing Committee, for having us appear today regarding Bill C-36, Protection of Communities and Exploited Persons Act. We appreciate the government's efforts to abolish prostitution and prostituted-related activities while taking a victim-focused approach. I'm joined today by a detective from our Vice team who is considered one of the foremost experts in the extrication of young women and children who are sexually exploited and trafficked for the purposes of prostitution. For the past 6 years, he has been dedicated to investigating domestic human trafficking. Due to the nature of his duties as an investigator, he will appear in camera today. If asked, his experience and observations will help explain what happens in the field from an investigator's perspective. As Chief of Police of York Region, an organization that polices a diverse community of over 1.1 million people, I'm proud to say that we have been recognized as a leader in combating and preventing domestic human trafficking from occurring, bringing predators to justice, and protecting and extracting sexually exploited women, children, and marginalized individuals from all walks of life. Over the past 4 years, York Regional Police has rescued over 100 victims trafficked and involved in prostitution, who mostly found to be under 21 years of age. More recently, our Vice team has laid 12 counts of human trafficking and over 80 pimping-related charges in the first 5 months of this year. In many cases, the women and children who are forced into the sex trade through violence, threats of violence, coercion, and trickery. We consider these women and children to be victims of crime, and we are committed to investigating all incidents related to sexual exploitation and human trafficking and providing assistance to these victims. Our experience leads us to believe that prostitution is exploitive, degrading, inherently dangerous to those who sell sex. We are thankful for the opportunity to provide our input on such an important bill. We have asked that the government develop a Made in Canada model, which gives police officers the necessary enforcement tools, is tough on pimps and johns, provides support for victims of exploitation, and does not legalize an industry that is inherently dangerous. It is our view that Bill C-36 accomplishes most of these goals. Specifically, we support the government's approach to abolish prostitution, prosecute those involved in the exploitation of others, provide support to those who are victimized, and reduce the negative impact to communities. We are also in support of the tough sentencing proposed for those who would exploit marginalized women and children. In the absence of new prostitution legislation, our ability to protect victims and vulnerable individuals, particularly women and children, would be impacted. I would like to emphasize the connection between prostitution and human trafficking. Sexual exploitation almost always occurs among victims of human trafficking. While human trafficking legislation exists, human trafficking can be difficult to identify until trust and cooperation is established with victims. For this reason, human trafficking and prostitution investigations go hand in hand. In 2014, York Regional Police initiated results in the arrest of 10 men for human trafficking in relation to the sexual exploitation of a number of women and girls 40% of whom were under the age of 18. Although we did not initially have grounds to lay human trafficking charges, we were able to rely upon prostitution-related offenses to separate these men from their victims. This gave us the opportunity to gain the trust of the victims, eliciting comprehensive statements to form the basis of human trafficking charges, as well as connecting those victims to support agencies. You see, without the criminal code tools, we would not be able to suss out the would-be victims and create the distance between the victims and the abuser. This is a time-consuming and often takes several attempts to gain the trust and confidence to help victims escape their abusers, not dissimilar to domestic violence. Within the confines of a body house or while under the control of pimps, victims are often afraid to ask officers for help. It is important to have the tools to separate victims from their exploiters, including the offenses of receiving material benefit for sexual services and procuring. Generally, during prostitution investigations, police in Canada recognize prostitutes as victims and vulnerable individuals. Certainly, York Regional Police has taken a victim-focused approach. It is important to stress that we do not seek to criminalize women in the sex trade. In the past 5 years, York Regional Police has not laid one single charge against a woman in the sex trade. In our experience, many prostitutes enter prostitution unwillingly, and most enter while they were in their mid-teens. Similar to the 2014 initiative that I mentioned, during a 2-week initiative in December of 2013, York Regional Police investigators identified 31 young sex trade workers who were previously unknown to police. Of those 31, nearly 30% were under the age of 18, and the average age of entry into the sex trade was 14.8 years of age. Investigators were able to assist all of those under 18 in getting home to a safe place for Christmas. However, without sustained help and support, it is our concern that most of these young women and girls are at risk of returning to the trade in a short time. Adequate funding for support services will be essential. Once victims are extracted from the sex trade, they need exit strategies, including access to programs and funding, which can assist not only with short-term accommodation and transportation needs, but also with underlying problems of substance abuse, mental illness, and the trauma of sexual abuse or exploitation. Through our investigations, we have noted that many sex trade workers come out of the business penniless and with significant personal challenges, including addictions. Our investigators have advised of incidents in which victims handed over thousands of dollars in cash to their pimps, only to flee with nothing. We commend the allocation of $20 million in funding as an important first step and hope that the government will undertake an analysis of what additional funding may be needed in light of the input it receives from stakeholders. Once Bill 36 is implemented, it is our hope that this legislation and related funding will continue to provide law enforcement with the tools of intervention to extract victims from the immediate dangers and connect them to victim services and support agencies. York Regional Police supports the legislative changes in Bill C-36 to reduce victimization with the objective of abolition of an inherently harmful and exploitive business. We look forward to continued participation during the implementation of Bill C-36. Thank you.
Thank you, Chief Jolliffe. Thank you for that presentation. Our next and final presenter for this panel is coming to us by video conference. Professor Eichberg, I hope I said that correctly, is a professor of law, and the floor is yours.
Good morning to you, and good afternoon from Copenhagen. I am, in fact, not a professor of law yet. I am a Canadian lawyer, and I've worked on prostitution and human trafficking issues since the late 1980s in a number of countries. First of all, I would like to thank the committee for the invitation to present at this hearing, and especially all the efforts you put into allowing me to participate via video link from Copenhagen. What I'm going to do today is I'm going to comment on certain aspects of the proposed Bill C-36. That doesn't mean that I fully endorse or not other aspects of the bill that I'm not mentioning. As the committee may be aware, I was the special advisor to the Swedish government for 6 years, and I was charged with the development and implementing legal and policy matters and intervention in relation to prostitution and human trafficking, or what is often called the Swedish approach. The Swedish approach, which is firmly steeped in principles of gender equality, human rights, etc., has also inspired other countries, as you well know, in Scandinavia, in the European Union and beyond, where the communities are working to shift the culture of the idea that prostitution is inevitable and towards the understanding that prostitution is something that individuals in a society should not have to be exploited through. Please ask questions about the Swedish approach during question times. I would be happy to discuss some of the issues that were raised earlier during this meeting. Let me go directly to the Bill C-36. I want to first comment on the preamble. First of all, I want to say that I'm happy to see that the government is taking action for the first time in Canadian legal history to comprehensively address the root cause of prostitution, those who create the demand, so those prostitution buyers, those men who are involved as purchasers, but also that they have intended to target those who profit financially and materially from the exploitation of mainly women in prostitution. To ensure effective application of any comprehensive legal framework that aims to prevent and tackle prostitution, it is essential, as we did very clearly in Sweden, state which values and principles such laws are informed by and rest upon, as the government has attempted to do, at least partly in the preamble of the bill. What is not visible in this preamble is that prostitution is a gender-specific violation. The majority of the victims are female, and the majority of the perpetrators, buyers, pimps, and traffickers are men. We also know that in Canada, Aboriginal women and girls are highly represented in both indoor and street prostitution. This needs to be reflected. I recommend that the preamble also include a paragraph that recognizes the international human rights obligations that Canada have under the Convention of the Elimination of All Forms of Discrimination Against Women, for example, and also under Article 9.5 of the Palermo Protocol, which obligates countries to criminalize or discourage the demand for prostitution purposes. The communicating for the purpose to provide a sexual service troubles me deeply, as it does, I think, everyone who is responding to the call to comment on this bill. It is most troubling for me to note that the government decided, despite plenty of evidence provided by survivors of prostitution and human trafficking, academic and community researchers, women's anti-violence organizations, law enforcement, today's witnesses, and some provinces, as to the multiple detrimental effects of criminal or administrative sanctions on those who are exploited in prostitution. Not only are they discriminatory, but they're contrary to the human rights obligations that Canada has signed on to. I believe that instead of facing criminal charges and potential involvement in the criminal justice system, like any other victim of a crime, victims in prostitution should be accorded all the rights and protection available through federal and provincial victims' Bill of Rights, and they should be amended to encompass an amended Bill C-36. I want to underline that in no legal system, no matter what measures that are taken, should those who are involved in prostitution be apprehended, fined, prosecuted, and jailed for something that is a crime committed against them and not by them. So I urge the government to reconsider and remove this offence from Bill 36. If the government still wants to ensure that prostitution doesn't exist in public places and close to children, should that be an important aim, the best way to do that is not targeting the victim, but targeting those who create the demand, the men who buy sexual services. We know that from Sweden. It is an effective way of discouraging men from taking part in purchasing a sexual service in the first place. I'm encouraged to see that the government has decided to put into place legislation or offence that criminalizes the buyers. I do have some comments on this particular offence. I will give some and the rest will come in writing. First of all, I want to underline and contradict studies that are going to be presented and have presented to the committee, which says or underlines that men who purchase women and men for prostitution purposes are benign, have a real interest in the victim's safety and protection. We know very well from a large body of academic and community-based research, and also from direct comments made by men who purchase women on websites that are located in Canada, but in the case of my research, I have looked closely at the big website in the Netherlands called hookers.nl, where men post the most horrific comments about men. About the women they purchase. I've also been involved in interviewing buyers in Lebanon, where we also can see that just as in all of the other countries where men who have purchased sexual services talk about the benefits they derive from controlling women in prostitution. To increase applicability, you need to ensure that attempts are criminalized, otherwise you will not be able to intervene until a violation has been committed. You need to increase the scale of the fines, which is in a very low level, to reflect the seriousness of the crime. A breach of this provision should mean a criminal record that cannot be rescinded even if they participate in the so-called Jones School. And, as has been done in Norway, the provision should be extended extraterritorially so that a Canadian resident who attempts to purchase a sexual service outside of Canada can be prosecuted in the country. Key to an effective and policy strategy to prevent prostitution offences is to ensure that individuals, groups, or legal persons are not able to recruit, harbor, or materially benefit from the prostitution of somebody else. It was recognized very early in the international community that there is a close link between the existence of legal brothels and other legal or illegal prostitution-related activities in a country and the attraction for pimps and traffickers to bring women, to bring men to those markets, and also for the men who purchase to actually show up in those markets. This has been soundly confirmed, both in the practical applications of 16 years of work that we've done in Sweden, but also through academic research, and importantly, evaluation in court cases that have been taking place recently in Germany and Netherlands, where they conclude that their system is attractive to those who facilitate and sell women for prostitution purposes. So instead of repealing the prostitution-related offences as the Supreme Court proposed, they need to be reformed, strengthened, etc. I also think that it's interesting to testify at the same time as the Adult Entertainment Association, because one aspect of the Canadian legal framework that is not federal, but is closely related in practice and effect to the actions that we are discussing today, is the municipal licensing system of strip clubs, body rub parlors, escort services, etc. The existence of such venue, I argue, has a direct impact on the scale and extent of prostitution-related activities and human trafficking within Canada, and of course the creation of victims both in Canada and in other countries. We also know that the opposite is true. If you enforce vigorously criminal provisions against the whole chain of perpetrators, buyers, pimps, and traffickers, we will also see that traffickers and pimps will not establish themselves in the country or in that particular community. And that has also, again, been recognized by those countries in Europe who have a legal or decriminalized system. I'm going to not say anything about the advertisement provision right now, though I just generally approve of it, but there are problems of jurisdictional aspects that I will leave in to be discussed in my paper. I also, already in 2007, when I testified to another committee in the Canadian Parliament, suggested that the government should appoint an independent national rapporteur on trafficking in human beings. That would have the mandate to investigate, monitor, and analyze the state and scale of prostitution and trafficking, but also all measures, legal and policy, to see if they're consistent with the Charter and with international human rights. So, in conclusion, in a democratic society where we strive for gender equality and equal treatment of everyone, no matter their background, this must include the right to live free from violence and exploitation, including through the exploitation through prostitution, no matter where that exploitation takes place, whether it is indoor, street, whatever. I urge the committee and in turn the government to resist the dramatic promotion of and resulting normalization of arguments about prostitution as individual choice or legitimate and empowering work in the Canadian public debate, put forward by what is called in international human rights theory pro-violation constituency, meaning organizations, individuals, etc., who, when their interests are threatened, lobby for and consent to policies associated with human rights norms violations. In the case of prostitution in Canada, such pro-violation constituencies are often, or may be, composed by individuals, groups, and organizations that directly or indirectly aim either to increase their exploitative access to victims, and in the case of Canada and other countries, that's usually groups of men who want to have better access to women and young men through prostitution in order to continue the exploitation. We have those groups in Canada. We have evidence that that is exactly what they're doing. The other aspect and the other pro-violation consistency is, of course, those who derive a financial or material benefit from the exploitation of those who are drawn into prostitution. As is in the case, for example, in the Netherlands, the business associations who want to expand their empires and make more profits. So, I think that it's long overdue in Canada that we identify prostitution and human trafficking. I have two more sentences. As intimately linked, understand them as serious forms of violence, systemic human rights violation. It's time to act responsibly, ethically, and decisively by criminalizing those who exploit, those who benefit, and ensure that those who are victims and exploited in the prostitution industry do not suffer any criminal administrative penalties. Thank you.
Thank you very much for that presentation. And now we will go to the question and answer portion of our meeting. And our first question from the Democratic Party is Madame Bovin.
Merci, Monsieur le Président. Je vais essayer.
Thank you very much, Mr. Chair. I will try to be precise and concise. Thank you to all of the witnesses for being present this morning. It is always interesting to hear a variety of opinions on a subject that is as complex as this one.
Testimony, Ms. Eckberg. En français, on a une expression qui dit les oreilles ont dû vous sciller. Si vous saviez le nombre de courriels que j'ai.
We have an expression in French just to represent how much feedback we have been getting. If you knew how much feedback we have been getting regarding what you have to say, well, I can tell you that what you have told us is similar to other things we have heard.
Also say to you, Ms. Grant, I felt your daughter. It's a good thing. It must be the worst ever to not know what happened exactly, to not have that finality part. I was talking about Shannon and Macy from Maniwaki yesterday, same type of situation that you don't know forever for sure. It's hell for a parent. I am sure. I can fathom the way you must feel, but we know what you're going through. Thank you for sharing your story. My first question, though, is for Chief Jolliffe. If I heard correctly, you're saying to us that it's been years since you've filed any a criminal charge against sex workers. I understand you correctly?
That's correct. In the last 5 years, we have not charged one.
Excellent. So what I'm interested to know from you is, with the criminal code as it is right now, and versus C-36 as the government wants it, what would be different in your aspect, and what exact new clause from the C-36 will make it that you can do your work better, maybe, or that you couldn't do prior? I mean, you couldn't criminalize clients before? You couldn't go after human trafficking before? Or what are we to understand exactly from your testimony?
Well, let me say that we always are looking for tools to help suss out those who have been victimized. And any opportunity the government can provide law enforcement to be able to do our job, try to do our job easier under huge financial constraints sometimes for us to do our business. Some additional things here that this Bill 36 gives us. The commodification of sexual activity goes after Johns, and
so you couldn't go after Johns before? Is that what you're saying to me?
Well, one thing for us when Supreme Court had come up with their final decision, we began to focus much more of our attention on the pimp. But this allows.
But you haven't gone after the. I'm trying to understand. You haven't gone after the prostitute in the last 5 years, and you're talking about the Bedford decision in December 2013. That now you can focus more on the. So who did you focus on?
So, the job is complex. So we are trying to inculcate ourselves into this business to determine basically if people are being exploited. This takes an enormous amount of time, and we need tools to be able to make this happen. So material benefit, for example, is important for us to see. Advertising business, that is helpful for us also to give us the grounds or the ability to separate. Once we think that we are onto something, be able to separate parties.
So can you explain to me how this bill is going to help your job? I'm not setting you up. I just want to know actually what new part of the advertisement. Is it the link to C-13, the fact that you'll be able to obtain some mandat de surveiller?
A warrant to supervise or provide monitoring?
It's helping you out from your understanding of the bill.
We have many laws in the criminal code. When it deals with investigating prostitution and human trafficking matters, many of the offenses that are in the code right now, I would consider as reactive tools. So we would, an assault has occurred, we get called to deal with the matter. Some of these additional items here.
Like what? That's what I'm trying to see.
So we've got commodification of sexual activity, presumption of financial benefit, procuring and advertising. Those things, we're able to look at each in their individual subset and determine if there's activities going around that.
And you couldn't do that before?
We could do that before, but this gives us some more authorities to continue on.
In what aspect?
It just provides us with the further tools to do the job.
Okay, I'll take this as an answer. You talked about the ladies from the Sex Professionals of Canada. You talked about the best, I think it's Ms. Lubovich, who talked about the, we hear a lot about the Nordic model. We heard a bit that from other groups it was the New Zealand model. What the hell is the New Zealand model?
So it's...
The heck I meant, sorry.
So it's a model that supports sex workers' rights under labor and health regulation. It would allow sex workers to work together. It affords sex workers the rights as other workers.
Does it, the New Zealand model, does it condone sexual assault,
No.
people that are not consensual? Is there other laws that
No.
surrounds it?
No, in fact, despite what we have been hearing, trafficking and prostitution are not the same thing. And New Zealand is a Tier 1 country, very high, the highest, I'm told, as far as combating trafficking. So,
So when you say prostitution is not trafficking,
Yeah.
you will agree, though, that sometimes prostitution can be part of trafficking.
I don't know if I understand the question. I guess what I'm saying is prostitution is not a violent activity, right? There can be things that...
I meant like it could be included. It's not equating, but
Yes.
there's cases. Let's
Yes.
just to be
Yes.
fair. Last question really quickly. For the adult entertainment, how do you define this? I'm still trying to find what sexual services in this bill means.
Yes.
Nobody is really defining it for me. The minister couldn't.
Yes.
How do you perceive it in the adult entertainment? Does it cover your business?
No, what we have defined as sexual services was created by a lawyer called Teresa Simone, and it's not the Bill Clinton definition of sex. But it's, if you want me to tell the terms I know, it would be actual or simulated intercourse, oral intercourse, masturbation, urination, defecation, torture in the context of a sexual activity. There's a long list of very poignant, detailed things, and it defines sexual activity. My statement to you, Madame Boivin, was that it's ambiguous. It always has been a gray area in terms of the advertising. They don't advertise for any of that. They use codes. Sometimes they use acronyms. And the legislation itself does not even define what that may be. And there's a gray area. It doesn't mean the Bill Clinton definition, for example. It could mean that. So it needs to be defined, for one thing.
Thank you very much for those questions and answers. Our next questioner is Mr. Wilkes from the Conservative Party.
Thank you very much, Mr. Chair, and thank the witnesses for being here today. Before I start, I just want to thank Ms. Grant for being here today. It's a difficult position that you're in, and I hope that your daughter comes home. I also wanted to say that having been involved in police work for some time and having been involved in next of kin, providing next of kin, I wouldn't wish that on anyone in this room. It's a terrible, terrible thing. And one of the ones that I was involved in was Angela Jardine, who was one of the victims of Willie Pickton. And her parents still live in my hometown of Sparwood, British Columbia. And they still struggle to this day. But they have closure. And so it is a challenge. Chief Joliffe, I want to ask you a few questions with regards to police procedure and some of the questions that my colleague, Ms. Boivin, was asking. Part of the sections in the code as they exist today, specific to Section 213, Sub 1, the offence in relation to prostitution, as it's stated, definition of public place, provides the police with opportunity to deal with those on the street in many different ways, and certainly the police have at their disposal a word called discretion that they use quite often, that they use more often than not. And I would suggest that in your testimony in which you've said that you have not charged anyone in the last 5 years under Section 213, your officers have used a lot of discretion. I wonder if you could explain to us, from the perspective of police work, that discretion that is used and how it is used.
Thank you. So police officers do have the discretion to lay charges, although that discretion is not absolute, but we do have the ability to decide based on factors if we wish to move forward with a charge, arrest and charge or not. And in this particular case, we use the power of sections in the code to inculcate ourselves into what's going on and to extricate individuals that are involved in the trade, to be able to have this conversation about what is going on. Are they comfortable in what they're doing? Are they doing that in their free will and so forth and so on? And in that case, what that does is it leads us to what we see as more important things. It leads us to pimps. It leads us to the human trafficking charges, which are far more important to us to get to. So based on that process, we will choose to use discretion to gain the trust and confidence of the worker so that they feel comfortable enough speaking to us and sharing what is really going on in their life, so that we have the ability to extract if required, or at least point them in a direction for treatment or services.
And I wonder if we could go along that same lines with regards to the services that that are available not only to those that you deal with, but also to the police. And that is from the perspective of discretion. Police officers utilize a lot of services that are made available to them, not only for people that fall under Section 213, but others as well. I wonder if you could speak to some of the services that are available to police.
I can tell you that in our business, we can't do it alone. So we have partnered with many social service agencies to help us, for us to have the ability to point individuals in a different direction. Some of those partners have spoken here before to this committee, and we value their ability to partner with us and their ability to educate us on what goes on in the industry, so that we can offer supports to those who we see as victimized.
I wonder if we could now change focus with regards to. There are some that we've heard witness from that have stated that why don't we just let the laws fall on December 20th, and then we'll move forward from there. I wonder if you could give us an understanding from a police perspective of the laws falling on December 20th of this year versus C-36. From the perspective of the police, if the laws fall, what can or cannot the police do versus C-36?
So we would lose the procuring piece. We would lose the communicating piece. And for us, we need these tools to be able to find out what's going on in this business. As I say, we're always trying to find out if individuals have been victimized, and without those tools, we don't have the ability to intercede, ask those questions, and help those individuals that are desperately needing the help.
So you mentioned also in your testimony with regards to the tools that fall under the Criminal Code of Canada to allow police to assist them in investigations. And you also spoke of how long it takes to formulate the grounds and then the evidence to proceed with charges under human trafficking, and that sometimes you use the other tools in the criminal code, such as 213, such as 212, such as 210, to move forward in that investigation. Twofold question, Mr. Chair, through you, Mr. Chair, to Mr. Joliffe. What would you say is the average time of investigation for a human trafficking charge from the time you start to the time a charge is laid? And what other tools do you use to try and get there? Because I think it's important for people to understand that this just doesn't happen overnight.
No, you're absolutely right. So for us to suss out an individual that we think is exploited sometimes takes weeks and sometimes it takes months. For us to engage ourselves in what an individual may be up to, our abilities to build, which is so important for us, is to build that trust and confidence so that someone actually feels comfortable coming forward to share what is actually going on in their life. And we can work files for days, we can work files for weeks, and we can work files for months. We have a dedicated staff of 7 in this particular area that every day of the week they are out in our community trying to disrupt this whole human trafficking piece. So as I said, in the last 4 years we have extricated nearly 100 young folks from this industry that we didn't know existed until we actually put the energies in and put the resources to it to find out what actually is going on here.
Thank you very much.
Our party is Mr. Casey.
Thank you, Mr. Chair. Chief Jolliffe, I want to follow up on a couple of things that were asked you already, and a couple of things that you've said. One thing that you said is that your department has not availed themselves of the power that you have in Section 213 to charge any sex workers in the last 5 years. But when you were asked by Mr. Wilkes about what would happen if on December 20th C-36 wasn't passed, you said, I'd be concerned that we would lose the communicating piece. You said the communicating piece is one that you don't use, but you're concerned about losing it. Can you explain that to me?
So that's the tool piece. That's what opens the door for us. So we use the section in the code to give us the authorities to interject ourselves into a process and then determine where it'll take us. And in most cases, it takes us in a much longer, lengthier route where we start to find out that the individual is they're under not on their own accord. And what it does for us is that it provides the opening of the door for us to get into to begin an investigation of something of much bigger magnitude.
So does that mean that you use Section 213 for the purposes of apprehending a sex worker, that you then attempt to extricate the sex worker with the possibility of a charge under Section 213 hanging over that person's head, and that you never actually deliver on what's hanging over that person's head? Is that what you mean by having it as a tool that you never actually use?
You know, as I said, we have never charged a prostitute for that particular section of the code. We use it as a tool to help us get to much bigger things.
And Section 213 of the code carries with it a maximum sanction of a $5,000 fine and 6 months in jail, correct?
It's a summary conviction offense, as written in C-36.
And as a summary conviction offense, it carries with it a maximum sanction of a fine of $5,000 and 6 months in jail, correct? You're nodding your head.
Yes.
That doesn't pick up. That's
Yes.
a yes? Okay. So if someone was applying for a job, and on the job application it says, have you ever been convicted of a criminal offense for which you have not received a pardon, or in the new language, a record suspension? And someone has been charged, I realize you haven't done it in 5 years, but someone has been convicted of Section 213. They can't rightfully answer no to that question on a job application form, can they?
No.
Thank you. Professor Eklund, thank you for your testimony. I'm interested in your comments with respect to the communication provisions, which I hope I'm not misparaphrasing what you said, but if I understand it, you think that the communications provisions which are being retained after a successful challenge are bad policy. Would that be fair?
If you're referring to the communication offense that is related to those who are exploited in prostitution, if that is retained, that would make bad policy, yes. But it would also have serious direct effects on the victims, obviously.
Thank you. I appreciate your comment that it's bad policy, and that was exactly what I was driving at. My question for you is as to, do you have an opinion as to the constitutionality?
Sorry, I didn't catch that.
Do you have an opinion as to the constitutionality of the retention of the public communication provisions in C-36?
As for the communication provision that relates to selling a sexual service as is phrased in the bill, I would argue that that is unconstitutional because it targets those who are victims of a, first of all, human rights violation, but also a crime. I think it would specifically be unconstitutional in terms of Section 15 on equality, gender equality basis, so the equality based on sex, but also under other provisions, which I think the courts outlined in some, to some extent in the decision.
Thank you. You referenced the absence in the preamble to any reference to the uniquely vulnerable position that First Nations find themselves in. I'd be interested to hear a little more from you on that. If there was reference to that in the preamble, how do you expect that might change the effect of C-36 and how it is interpreted and applied by the courts?
If I look at our experience in Sweden first, it was incredibly important to us when we created the Swedish approach and then implemented that what we did was based firmly on principles. And in our case, we looked at gender equality, international human rights, and anti-discrimination or non-discrimination policies. Those are inscribed in a different legal system in Sweden, in the Travaux, which underlines the legislation that we passed when it comes to criminalizing the buyers. In this particular bill, the government has outlined certain principles why they have decided to go the way as they have decided. What is lacking is a general reference to international human rights and the obligations under that, which includes looking specifically at the discrimination of Aboriginal peoples in Canada and other places. So my approach to this is that there should be references specifically to the CEDAW Convention, to the general international instruments that says that prostitution is an affront to the dignity and human worth of the person. And I think that Canada could take a step forward and also make a reference to the Declaration on the Rights of Indigenous Peoples. It's not binding, but it does state a commitment to specifically take into consideration the particular oppression and discrimination that Aboriginal people suffer in Canada, specifically women and girls. So yes, it should be included, definitely.
While on the subject of international obligations, I expect you're probably aware that the Parliamentary Assembly of the Council of Europe has passed a resolution calling on countries, including Canada, to include certain things as they deal with prostitution. And one of the things that the Council of Europe has called on Canada to do is to make specific efforts with respect to research and data collection. What you may not know is that the research budget within the Department of Justice has been cut because it doesn't align with the government's objectives, and there's nothing in this bill that talks about it. There's no reference to it in the $20 million allocation. Your opinion on that?
Again, just as an aside, I am a Canadian citizen and I have lived in Canada for many years, so I'm quite aware of the system. I think if we want to take a comprehensive approach to the prevention and tackling of prostitution, that needs to include aspects of, for example, training of police, research, impact assessments of all provisions, not just the one that we're discussing now, other policies, etc., and evaluation potentially of whatever will be in place at the end of this process. I don't believe, having worked close to those who make decisions in a government, I don't believe in Sweden as in Canada that it's about lacking money. I think it is about equal distribution of funds, and so there needs to be a decision made and making this work a political priority, as we did in Sweden, where the government took a specific decision to integrate the work based on gender equality into the gender equality strategies that are a cross-party parliamentary strategy accepted by everyone.
Thank you very much.
And in that is, of course, the measures, but also money.
Thank you very much. Thank you for those questions and answers. Next questioner is Mr. Decker from the Conservative Party.
Thank you, Mr. Chair, and thank you to our guests. Ms. Grant, I just want to join with my colleagues in expressing my wishes that your daughter comes home soon, safe and well. And thank you for sharing your story with us. I want to start with Mr. Lambrinos. First of all, thank you for the kind offer for the site tour later today. I regret that I will not be able to join you this evening. Earlier, you introduced me to some of your members, I believe the owners of some of those clubs that you've invited us to view today. The gentlemen are sitting here in the room. Do you want to introduce them to the
Correct.
To the crowd?
Mr. Doug Pettit, please stand, is from the New Den.
Please.
Earl Bentivoglio is from the Fairfax, and Remy is manager at the Fairfax in Ottawa, downtown.
Very good. Welcome to you all. So, as I understand it, Mr. Lambrinos, your concern, the concern of the Adult Entertainment Industry Association, is the definition of sexual services in Bill C-36. You're concerned that the types of activities that go on in your members' clubs might fall under that definition. Is that correct?
Well,
is that your concern?
That's not the concern.
Okay. Is that a concern?
No.
Okay.
No. What it is, and I appreciate Madame Beauvin asking the question earlier, these types of activities are prohibited in adult entertainment clubs.
Okay.
They do not occur. And in terms of...
So nothing that you or the average Canadian would understand as being a sexual service goes on in any of the clubs that any of your members operate?
I'm not saying that it never ever happened.
Okay.
I'm not saying that, sir, at all. But
okay,
it is a prohibited activity. It happens no more or no less than anywhere else. What the definition was created for was defined to ensure that there was no ambiguity in place. And I'll tell you, Mr. Decker, part of the reason is not only the education that we have, not only the rapport that we have, but it's the physical setup within the area that if you were able to attend, you could see that the private dance area is an open access area. It's not behind a closed door like it would be in a massage parlor.
Okay.
The problem is, Mr. Decker, just one thing. The problem is that in the massage parlors where they advertise with all these acronyms, they are behind locked doors.
Right.
They are behind. There's very limited language capabilities, etc.
And none of
that
those
was my
massage parlors
concern.
belong to your association, correct?
Pardon me?
None of those massage parlors are members of your association.
No, they are not.
You don't represent them.
No,
Okay,
we do
fair
not,
enough.
sir.
So I understand. So you're not really concerned that C36 will affect your members, but you and you said earlier that the laws that were struck down under Bedford didn't.
They don't
affect in any
No,
way.
and I point out,
Okay.
Mr. Decker, that there had not been a single licensed adult entertainment club charged in the last 5 years with any of the
Fair enough.
struck down laws. So we know we're doing a good job.
So under the old law, under the new law, there really isn't a problem. Your owner should be able to carry on business in the normal course as they do today.
However, I wanted to point out, you're right with the advertising, because we need to be proactive about things too. These places that actively engage in sex acts, even the chief of York will affirm to this, that are advertising for it with their acronyms, are creating a negative impact on our performers, on our entertainers as well, because they realize you can go over their customers and get more bang for your buck, but meanwhile, lap dance is not intercourse, and then there's pressure put on, so they've been a nuisance to our industry.
So your concern is that the massage parlors and the advertising that they do infringes on the business, the legitimate business that your members are carrying on?
Correct. These types of places, Mr. Deckard, cannot live by word-of-mouth advertising alone. And it's because they've been getting away with this ambiguity. And my point was that there's good intentions, perhaps. However, you don't even define what the word sexual activity is.
Okay.
And there's no tools in place for the chief to implement these. They have all these things now, is what many members point out. There's pages upon pages of
Those are all
what
for
this is.
massage parlors, none of your clients.
No, they do not
business.
advertise in here.
Okay,
The
all right.
paper called them adult entertainment.
Fair enough.
But in my view, it's not entertainment. How is this entertainment? There's nobody
So
watching a show.
Your concern is that the advertisement provisions might somehow negatively impact the businesses of
It's
your
already been
clients?
pointed out, Mr. Deckard, by your colleague, that somehow the licensed adult entertainment clubs are connected into the advertising.
No,
and they are
well,
not.
what we have heard from some stories from some of the women who have testified before the committee this week that they were trafficked into strip clubs. I don't know if they were members of your association, certain places in Canada, and that there was some linkage between the two. But those are just the testimony of the...
I'd like to answer that.
Well, those are just the
But was anybody
testimony
charged
of
in
the
those
answers.
cases? Like, I hear anecdotal evidence, too. Was anybody charged? Those are wild
I don't
allegations,
know-
strong statements.
Sure they are. I don't know the answer to that question. What I'm just saying to you is that it was simply what we heard, okay?
Right.
So
And I
let
would
me
be
let me
leery
ask you
about
one
that.
more question, then time's short, and I want to move on to Ms. Scott and Ms. Leibovich. You mentioned the words, well, let me ask you, are you a lawyer? Okay. Okay, so you're not a lawyer, but you mentioned the words malicious intent and libel.
Yes, sir.
Have you done any research into those terms? Do you have any?
I didn't mean it to be a legal
training?
opinion.
Okay, all right. Fair enough.
If
Then we'll leave it
if
there.
I can expand on it, though.
No, it's all right. It's all right. I
would
just
like
I just wanted to find out if you had studied it as a person learned in the law.
No, but I
and
would
your
like to
answer is you
answer
have not.
what it's called the
But
rule of law.
I'm sorry. We're out of time. I want to
Gotcha.
move on to Ms. Scott.
Yes, sir.
Ms. Scott, you mentioned in your opening statement that you think that Parliament should just let the laws expire, let the laws that were struck down by the Supreme Court fall, and then what would apply simply thereafter would be employment and labor law. Correct?
Yes, I believe the Supreme Court struck them for a very good reason.
Okay. So
25,000 pages worth of reasons, really.
Okay.
And
So I'm sure you're familiar with the Bedford decision and Chief McLaughlin's statements and comments in her decision. So I'll just read one point to you. She said, "This reflects a policy choice on Parliament's part. Parliament is not precluded from imposing limits on where and how prostitution may be conducted, as long as it does so in a way that does not infringe the constitutional rights of prostitutes." So what is she referring to in terms of
What is
imposing
Chief Justice
imposing limits?
McLaughlin
Yeah, what is she referring to? I specifically want you to focus on the words imposing limits on where and how prostitution may be conducted. If you say they can just let it fall away, but she's saying Parliament does have the right to impose limits on where and how prostitution may be conducted. What do you think she's referring to in that phrase?
What do I think?
McLaughlin is referring to.
What do you think
Okay,
Chief
she
Justice
did
McLaughlin is referring
mention
to?
that if it so chooses, and obviously you do so choose, it's not a necessary thing for you to do. But I think it's extremely important to scrap this bill in its entirety. And if you're going to do that, come at it from a different approach.
Fair enough. Okay,
Bring
I take
sex
your point.
workers
I
to
take
the
your point on
table,
that.
but for real. The sex workers were not consulted.
But what do you think Parliament's role is in regulating and imposing limits on where and how prostitution may be conducted? Because she said Parliament does have the right
Yes.
to do that. Do you agree or disagree with her?
Do I agree with the
Yeah,
statement?
do you agree with the Chief Justice's statement that Parliament has
Yes,
the
it
right
does
to
have
impose
the right
limits
to do
on
so.
prostitution? Do you think she's right?
I agree that she
Okay.
has the right to do
All right.
so, but it must do
So let me ask you the next
in a way
question.
that doesn't start killing us
I
all
understand.
over again.
I understand, and that's there, and we read that. The next question, though, is what is the federal jurisdiction that you would see the government using to comply with her statement that Parliament has the right to impose such limits? You mentioned labor law. You mentioned
Yes.
employment law. Others have mentioned zoning law. None of those are in the jurisdiction of the federal
That's
government of
right.
Canada. So why did Chief McLaughlin say that Parliament has the right to impose
Well,
limits?
it does so already. There are many, many, many laws on the books that deal with sex work and the exploitation of it. For example, as I opened with, it was only 1/10. We only challenged 1/10 of the Avails law. There's quite a list, almost like a catalog of other.
But those weren't
offenses
struck
there.
down, so that's not what she was referring to.
I beg your pardon. So that's what I'm referring to.
That's not what she struck down, so that's not what she was referring to. Okay, thank you, Mr. Chair.
Okay, your time is up. Thank you very much. Thank you for those questions and answer. Our next question from the New Democratic Party is Mr. Jacob.
Thank you very much, Mr. Chair, and thank you to the witnesses for being with us this morning. I wanted to say, first of all, that I empathize, like many of my colleagues, with your situation, Ms. Grant. My first question is for Mr. Jolliffe. In your preliminary statement, you spoke of drug addiction. Currently, mental health services and help offered to drug users who are also prostitutes and vulnerable women, are they sufficient in your region and elsewhere in the province, throughout the country even?
They're not totally sufficient, that there needs to be more opportunity for folks to avail themselves to services that need to support those with addictions and mental health. We see that in our industry every day of the week.
Merci, Monsieur.
Thank you, Mr. Jolliffe. You spoke of the $20 million which the government is going to invest over 5 years. Do you think that $20 million over 5 years for all of Canada demonstrates that it is acting seriously?
I'm looking from a positive perspective here. The fact that it's a start. I'm not sure, quite frankly, if it is enough. That's why I said in my comment it's a good start. I think I think that once there's some further evaluation of the possible usage, then one would have a better idea what would be probably the most appropriate dollar value to put to that.
Merci, Monsieur le Président.
Thank you, Mr. Chair. My second question is for Ms. Scott and Ms. Libovich. You said, what I retained from your statements, you said that this bill, talking about Bill C-36, is that it is highly imperfect and does not respond to the Bedford ruling, will not improve women's security or safety. My first question that I would like to ask you is, how is affordable housing and the reduction of poverty going to help sex workers leave prostitution?
I don't know what the question is.
She's having trouble hearing in here. The question was around how poverty and affordable housing will allow for sex workers to leave the business. So I think that addressing poverty and affordable housing should be what we should do for everyone, right? In Canada, right? It's an issue that lots of Canadians face. If I can just say, in regards to New Zealand, there are in place in the model, there are occupational health and safety guidelines and provisions against exploitation right in the New Zealand model against youth and sex work, around business licensing, but not individual licensing for sex workers. So I just wanted to add that in, but I think poverty and affordable housing is something that we all need to address for all Canadians.
I agree. I don't think that any one particular group should be singled out. I think but Canada really could do a better job on that, in my opinion.
Exact. OK. Donc, je voulais savoir.
You spoke of the New Zealand model. What would be the real impact of Bill C-36 on your daily lives?
Yes. So he was talking about how Bill 36 will impact sex workers' lives. I sort of mentioned in my talk, those working on the street, when you target our clients, it puts us in danger, and we see that in Vancouver, and we see that where it has been done. It's a way of pushing us further away from our communities, away from services that we need. As I mentioned, clients are paranoid of the police and will go into areas that are out of the way. And that's where we have to go, right? And for indoor workers, very concerned about the advertising. We see in the U.S. sites are closing down. We're not able to advertise. And then again, for indoors, our clients are targeted, right? So we see in Sweden how they get information on the clients is by going to areas where sex workers are working out of their home or a hotel, and they watch that hotel and watch to see when clients are coming. And so we are afraid of that.
And like any business, we go where our clients are. And when you force us into dark industrial zones, and like what happened in Vancouver, and those were also known as Robert Pickton's killing fields. This will happen to us here, again, with this bill. I can see it. I also am old enough to know how this works when you have this kind of criminalization. And the way brothels used to work prior to the 78 Hutt decision. And how we worked was there were the mob pretty much ran things, unless you were lucky enough to live in Halifax, where Ada McAdam, a well-known madam, ran several satellite brothels throughout Halifax and Dartmouth, and working with Ada was okay. But in Toronto and Montreal and Vancouver, there were brothels were primarily owned by guys with muscle and who could pay the police off, and word of mouth, and that's how it got to. The advertising had to be. So we need to go where the clients go. You end up working in one of those brothels. very, very underground.
Thank you, Mr. J. Those questions and answers from the witnesses. Our next questioner is Monsieur Gauguin from the Conservative Party.
Thank you, Mr. Chair, and thank you to all the witnesses for your testimony. It's certainly very diverse, and it'll be helpful in our deliberations. And, of course, Mrs. Grant, like the other members, certainly the best of lucks in rejoining your beloved daughter. I want to address my questions to Mrs. Ekberg. Your testimony has been long awaited as the author of the Nordic model, of course. As you know, C36 has taken a number of the elements from the Nordic model, particularly targeting the pimps and the johns and the criminalization. I trust that as the author of this model, you've followed its results on the prostitution industry afterwards in Sweden.
Sorry, I didn't hear the last part. You trust that?
I trust that you followed the results of what the Nordic model has done in Sweden after it was implemented.
That's right. In 2008, a special inquiry was put into place, chaired by the Chancellor of Justice, looking at the effects.
Because we're short for time,
yes.
I want to focus on a couple of things. I know you've said
okay.
What effect had the Nordic model had, once it was implemented, on prostitution? Was there an increase, a decrease in prostitution? Was there an increase, a decrease in human trafficking? What results did it have, and what do you base yourself to make those statements?
The inquiry did a comparative study between Sweden, Norway, and Denmark, and at the time, Norway did not have the provisions that criminalizes the buyers, nor had they the more comprehensive approach that Sweden took. And in Denmark, the approach is to not implement the legislation that is still on the books, to a tolerance model. And what they concluded is that on all of the questions that you asked me, that the level of, or the number of individuals in prostitution had dramatically gone down, and in particular in comparison to countries that did not have our approach. And specifically, the country that had the largest number of victims is Denmark, on percentage of their population, due to the fact that they have, if I look out the window here, I see nightclubs. And in reality, in Denmark, there is a very viable prostitution industry, which we do not have in Sweden. The National Rapporteur on Trafficking, which we've had since 1998, concluded a long time ago, and the Special Inquiry concurred with her conclusions, that having legislation and vigorously enforce it against both the prostitution buyers, the pimps, and the traffickers makes a country less attractive. This was doubted by German and Dutch police, but they have recently, in the last 2 years, turned to the Swedish police to ask how we managed to keep the involvement of organized crime down, whereas in the Germany and the Netherlands, there is now, I would say, a catastrophic situation where just this Monday, the appeal court in the province of Utrecht affirmed a decision to close down the whole prostitution district in Utrecht, 143 brothels, because of organized crime involvement. So, whereas we have a diminution of numbers in the countries of the others, it's going up.
So in summary, it's greatly...
And that is based on facts, not arguments.
So in summary, it's greatly diminished the level of prostitution and human trafficking as a result of its implementation. That's what I take the succinct answer to be, correct?
That's correct, but I also want to say that in 16 years that we've been doing this, we will not be able, of course, to eliminate prostitution and human trafficking completely. And also, I want to add also... Sorry?
What about the issue of violence? There was always a question of whether the level of violence. I mean, some of the witnesses here have said that, listen, targeting the Johns will drive the prostitutes further underground, make their, profession more dangerous. Was there an increase in the numbers of violence with prostitutes as a result of the implementation of the Nordic model? Did you see any result whatsoever, good, bad, or otherwise, from a point of view of violence?
First, let me look at both underground and violence. First of all, it's impossible for prostitution to go underground. Underground is not a place. In order for buyers to be in contact with those they want to purchase in prostitution, there needs to be a communication. That can be through adverts, that can be online, that can be in the newspapers, as was shown by the Adult Entertainment Association, different methods of making contacts. As much as the buyers can get in contact with the women who are in prostitution or the men who are in prostitution, so can the police. And the Swedish police has spent the past many years doing investigations online on websites that advertise the sale of women and the purchase by men in Sweden. And so underground and violence was also concluded in the special inquiry, but also if you talk with women who have experience in prostitution in Sweden who are not related to the prostitution industry, they will tell you that the prostitution industry as such is a very violent place to be. And there is no correlation between lesser number of men and increased violence, because men who are violent, the Prostitution Act is a violent act in itself, the use of women, sexual violence. But there's also no guarantee that those who are stopping buying are less violent than those who are in the industry. The special inquiry had consultations with women and men with experience in prostitution, and who clearly declined. I'd be happy to give you a copy of the document if you would like to read it yourself.
Thank you very much. Thank you for those question and answers. Our next question from the New Democratic Party, Madame Pate.
Merci beaucoup, Monsieur le Président. Thank you very much, Mr. Chair, and thank you to all of our witnesses. I'll ask my questions quickly. As you all know, we don't have a great deal of time. My first question is for Ms. Ekberg, please. I think it's important to mention that the Nordic model is somewhat the Swedish model, because we know that Finland and Denmark and many other countries in Northern Europe don't exactly have the same model as Sweden. I would like to hear you about the fact that, yes, Sweden adopted a criminalization model. They criminalized the purchasers of the service. It is important to know, however, that all of their legislation was accompanied by social measures that were very sweeping in nature. Such a model cannot work if the government and authorities do not have the resources necessary in order to help, as it has been suggested, to help victims exit that situation. I would like to hear what you think of the situation that we have here. We have a bill which does not respect the Nordic model because it still criminalizes women. You mentioned it in your opening remarks, and the bill is not accompanied by social measures as were implemented in Sweden when, in 1999, it passed its own laws. Can we really apply all the numbers that we've heard here to Bill C-36? I have doubts.
It is true that Sweden has a more comprehensive approach than other countries, mainly because our focus on this started 10 years before the other two countries in Scandinavia who have done it. But if you look at other countries in Europe that are now considering doing a similar system, which is actually not a criminalization system because women are not criminalized, and that's key to our, but the perpetrators are, and so they should be. If you look at the French bill that is now pending in the Senate, it's also, which is a bigger country than Canada with lots of social problems victims and financial and economic budgetary difficulties that are, I would argue, bigger than here. But they have still decided that they're going to pass a legislation that is very similar to us with social measures, etc. I think the model is applicable everywhere, but as I said in the response to one of your colleagues, it is necessary to make the implementation of such a model a political priority. And that political priority should, as you rightly point out, also include measures that ensure that victims have a viable access to viable exit program, but also long-term.
Can I just ask you a quick question before I move on? Would you still support the bill in its entirety if it still criminalizes women?
As I told you before, I don't support the bill and in its entirety because I disapprove deeply of the criminalization of those who are victims in prostitution, and I think that is unconstitutional and contrary to any gender equality or human rights measures. I do, however, support an amended bill which would be accompanied, that would be accompanied with access to services, funding, etc.
Thank you very much.
And I also, I just want to say also that we start somewhere and then we change things as we go along.
Thank you very much. Ma prochaine question, et je suis désolée, je vais juste...
My next question, I have a quote from the Minister in his opening remarks. My question will be for Mr. Lambrinos.
Bill C-36 also seeks to continue to denounce and prohibit the exploitation of prostitutes by others, by third parties, commonly known as pimping. This includes the institutionalisation en français of
institutionalization,
such as strip clubs, massage parlors, and escort agencies in which prostitution often takes place. All of these capitalize on the demand created by purchasers. So what do you have to answer to that?
And that was the concern I was trying to bring up to Mr. Deckard as well. I don't know what data the minister is trying to quote that from, but it is erroneous. The licensed adult entertainment clubs currently, the entertainers that work there should not be in the category, in the same category. And the reason is, and it's from a market demand perspective, 75% of customers that go into a licensed venue, which I invite you to, Madame Bouquet, as well, aussi, ce soir, that go into the establishment do not get a private dance. They're there for three reasons. One is to socialize. These are party atmospheres as well. Socializing for the entertainers, very important. Two is to just relax, and three is to watch something. It's only 25% that would get a private dance. And we know that the amount of actual intercourse or sex acts that would happen in private dance is minimal because of the number of charges, plus the number of the types of women that work as entertainers currently are students. There's an increase in number of students that are working that can make their money lap dancing, that don't have to be a prostitute to intercourse, etc. So we know the demand is not there. We know we do an adequate job, a very good job. We actually work together in educating the workforce. We're sex interdit as well. So we know it's a good opportunity. And it was unfair of the minister to group the licensed adult entertainment clubs in the category. It's unfair for them to group the women that work in the same category, because if you look at the newspapers, and it is a bit of ignorance that was done, the newspapers call it adult entertainment. And licensed adult entertainment clubs are strip clubs. So this whole business about a massage parlor, it's nothing more than a gray area. We know what a massage is. What organ, what part of their body are they massaging?
Thank you for those
we know
questions and answers, and I think you made your point there. Thank you very much, everyone. And our last question for like 2 minutes is Mr. Decker from the Conservative Party.
Mr. Chair, I'll be brief. Ms. Leibovich, it's nice to see you again. We met earlier in the year. Thanks for being here today. I'm just looking at paragraphs 11 and 12 of Chief Justice McLaughlin's decision in Bedford, where she describes your situation, your experience. She said that you had worked in the past with an escort agency, as an employee of an escort agency. You had worked in the street, and you had worked in your own private indoor location. And in paragraph 12, she says, presently, Ms. Leibovich primarily works independently out of her home. And she went on to say that one of your fears was that you might be found, charged with being found in a common body house under the laws that were struck down, and therefore you might actually lose your home. So C-36 provides an exception for you, correct? You don't have a concern about leaving your home. She went on to say that you were concerned that your partner might be charged with living off the avails of prostitution and obviously suffer criminal consequences. That C-36 allows specifically as an exemption for partners in legitimate living arrangements, so that concern is dealt with. And finally, she said that you were concerned that if you went out on the street, it would be inherently much more dangerous, but if you could carry on the business indoors from your own private location where you could properly screen your clients, then you would be safer. And so C-36 to that extent, I think. Well, just let me do that. It does address at least those issues set out in paragraphs 11 and 12 of Chief Justice McLaughlin's decision. I can't screen my clients. Well, she talks about the things that you were concerned about. So did she leave something out of her decision or her description? Okay.
I don't really understand the.
I'm just trying to point out that I think those were addressed by Bill C-36. The things that Chief McLaughlin said you were concerned about are specifically addressed.
Could you let me speak for a second? Sure. Are you asking a question or making a statement?
I'm trying to make the case that people understand, people in the larger audience understand, Ms. Leibovich, that my interpretation, my reading of Chief McLaughlin's decision is that she stated what your concerns were. The government read those concerns and addressed them in Bill C-36.
No, you did not.
Okay.
Okay. Oh, and how you didn't was I cannot screen my clients. You are criminalizing my clients. The cops are going to be, how do you think the cops find clients? It's going to be from the places that I work, right? Out of the places that I work.
Mm-hmm. Thank you very much. Thank you, our witnesses today for the first meeting this morning on this discussion of Bill C-36. I want to thank you for taking the time and providing you with your views. We'll be going into camera for a half an hour period. And from our friends from the Adult Entertainment Association, thank you for the invitation, but I don't think you'll have much of a crowd here tonight from this table anyways, but you never know. With that, we will suspend while we go into camera. Thank you for joining us. For about 3 or